Good afternoon, everyone. My name is Paul Johnston and I chair the Northern Ireland Regional Committee for ACE. You're very welcome to this ACE Insight webinar, the first to be organised by ACE Northern Ireland since the start of the COVID crisis, but obviously not the first webinar that ACE has organised. We've had lots going on in the past number of months. Today we're going to have a construction and engineering law update from industry experts Stuart Murphy and John Dugdale, both partners at Carson McDowell. Stuart leads the firm's construction law team. He has over 25 years experience of advising construction and engineering clients in relation to both contentious and non-contentious matters in Northern Ireland, Great Britain and internationally. He has extensive experience of major industry standard forms of contract, including our own ACE agreements and many others. John advises on the entire project delivery process from end to end. He is familiar with the drafting and negotiation of all the standard forms of contract used in Northern Ireland and elsewhere, and has extensive experience of working with contractors, subcontractors, consultants, clients, funders and insurers in a wide variety of market sectors. Both speakers regularly act for clients in dispute resolution, including mediations, adjudications, arbitrations, and litigation. Over the past few months, there have been a number of important decisions from the courts that are likely to have significant impact on engineering projects, parties' entitlements under engineering contracts, and the process of resolving disputes that arise in relation to engineering work. At the end, there will be a Q&A session, and I'll explain how you can send your questions through on the next slide. Next slide, please, Julie. And the next one, housekeeping. So repeat listeners will know all about this, but good to remind everyone. The webinar is best experienced through headphones, which will help to cut out background noise. Attendees are all automatically on mute for the duration of the webinar. To ask questions, please go to the questions in the control panel, the sidebar on your screen. We'll try and answer as many as possible, but don't worry, we'll also answer any others we haven't had time to cover after the webinar. Don't worry if you miss anything. We'll be uploading this to our website in the next few days, so if you want to listen again, you can. I'd like to welcome now our first speaker, Stuart Murphy.
Paul, thank you very much for that introduction, and welcome everyone who's watching and listening. John and I are going to take some time in the session this afternoon, just as Paul has said, to talk through some hopefully interesting and certainly recent developments in the law on construction and engineering contracts. We're going to cover two broad areas. John's going to come on in a little while to talk around dispute resolution and adjudication in particular. But in this first session, I wanted to highlight some issues to do with payment under construction and engineering contracts. And I think this hopefully will be relevant to the audience, both in relation to the appointment contracts that you yourselves may enter, which are very likely also to be construction contracts for this purpose, but also in your role as contract administrator of any construction contracts, and the role that the administrator has in relation to certifying and giving notices in relation to payments that need to be made. I thought just before we get into the two specific cases that I wanted to draw to your attention, it might be helpful just to remind ourselves a little bit about what the requirements are in relation to payments under a construction contract. And what we're talking about here is what the Northern Ireland Construction Contracts Order requires in this respect. And so just very briefly, and I suspect this will be well known to many of you, but it's a requirement that a construction contract has a right for payment in either in installments or stage payments or in some other way, but in stages throughout the duration of the contract, where the length of the contract is at least 45 days. Now, in my experience, that doesn't tend to cause much controversy, but where problems do begin to arise then is in the second requirement, which is that a construction contract has to provide an adequate mechanism for determining both what payments are due and when they become due. And what that's interpreted to mean is that there is a requirement that your contract has to provide for when the payment due date is for each payment under the contract. And then also there's a requirement that within 5 days of that due date, you are required, if you're the paying party, to give a payment notice, as I say, no later than 5 days after the due date. Following on from that, then, it's also a requirement that the contract provides for a final date for payment, which is the actual date when money has to pass hands. And at the final date for payment, it's a requirement that the paying party then has to pay what's called the notified sum. And the notified sum normally will be the amount stated in the paying party's payment notice. And if for any reason the paying party does not intend to pay the notified sum, then it's important that it serves a valid pay less notice indicating the amount that it does intend to pay, and that it serves that no later than the prescribed period in the contract, which will be a number of days prior to the final date for payment. You'll be familiar, I suspect, that the likes of an NEC contract has a 7-day period for the service of pay less notices. Under JCT, it's 5 days. But quite often that's amended in contracts to be a different period. But whatever that period is, it has to be, the pay less notice has to be given that number of days before the final date for payment. Now, where all of that sometimes comes a cropper is if the paying party either doesn't serve its notices, its payment notice or its pay less notice, or it in some respects gets those notices wrong in that they're too late or don't have the information in them that they should. And what a construction contract order provides in those circumstances is that there's the opportunity for the payee, the receiving party, to serve its own default notice stating what it considers is due. And how that in practice more often happens is that the receiving party will have put in a payment application prior to the date when the payment is due. And in the absence of proper notices from the paying party, that application then becomes the default payment notice. And the receiving party, in the absence of any other notices from the paying party, is entitled to be paid what he has applied for. And that's where we get this concept of a smash and grab, so-called smash and grab adjudication that you may have heard about, namely an adjudication based not on what amount of money is properly due under the contract, but the amount claimed will be the amount applied for by the receiving party, and an allegation that no payment or pay less notices were served by the paying party, and therefore the paying party has to pay what's applied for. So that's a bit of, hopefully a bit of a refresher on payment and what's required in construction contracts. I want to come on now to look at a couple of cases that have been decided over the last few months. And the first of these relates to or gives us an example of the importance of making sure that your contract has an adequate mechanism for determining when payments become due and making sure that there's a clear final date for payment. This is a case of Rochford Construction and Kilhan Construction. It's a case that was decided by the English TCC, Technology and Construction Court, in March of this year. And it involved a contract between Rochford and Kilhan for Kilhan to construct a reinforced concrete frame for a college in Richmond. And the dispute, probably a fairly traditional dispute, arose around what Kilhan was due to be paid in relation to a particular application. They'd put in an application for just under 1.4 million in May 2019, and Rochford had issued a payment notice several months, as it turned out later, in October 19, saying that the sum due, or that it considered was due, was only just over 1.2 million. And the issues that the court had to determine were whether the application that Kilhan had put in was a valid application. If it was, when was the payment due date in relation to that application? When was the final date then for payment? And depending on the answer to that, was the October 2019 payment notice that Rochford had issued, was that a valid notice, or was it out of time? Now, part of the reason, I suspect, why this ended up in the courts and why there was a dispute was that the parties weren't using any sort of standard form contract. They were using one which the judge, in her judgment, described as a misfire and neither clear nor free from ambiguity. But the key terms of that contract are there on the screen. The contract talked about the application date being end of month, that valuations were to be monthly as per the attached payment schedule. The payment terms were 30 days from invoice, and that the payment certificate was to be issued with the invoice. And not only was there uncertainty about what those terms in themselves actually meant, but the position wasn't helped any by the fact that despite the references there to attached payment schedule, there wasn't actually a payment schedule attached to the contract. So it was clearly incomplete in that respect. So the first question was, what did application date end of month mean? Rochford had tried to argue that meant that Kilhan's application had to be issued at the end of the month, on the last day of the month. And because it was issued on the 20th of May, it was out of time and therefore wasn't a valid application. The judge disagreed with that and said that no, the words application date end of month meant not that the application had to be submitted at the end of the month, but that the period to which the application related ran up to the end of the month, and so that an application submitted a number of days after the end of the month was still valid because it was covering the work that had been done in the preceding month. And I highlight that only, I mean, it's fairly fact specific on those words, but I highlight it only to show that it's very easy for parties to end up with a result that they weren't anticipating by a loose use of language in this area. And I'm sure Rochford may well have intended that applications were to be submitted at the end of the month, but that's not what was achieved by those words. The real issue in the case then became when was the final date for payment. And that circulated around the question of what was meant by the term that payment terms were to be 30 days from invoice as per the attached payment schedule. Well, as we know, there wasn't an attached payment schedule, and Kilhan hadn't submitted an invoice prior to the date of Rochford's payment notice. And so Rochford argued, well, the final date for payment has never accrued in relation to this payment because there was no invoice, and the final date for payment is only triggered once an invoice has been issued. And that, you might think, is what the words there viewed in isolation may mean. But actually, what the judge found, and she said she found it with some diffidence, so some uncertainty in her mind, but she said that whilst a due date, a payment due date, the first of the two key dates, can be fixed by reference to an invoice or a notice, the final date for payment is different, and it has to be pegged to the due date and be a set period of time after the due date and not triggered by an event or mechanism like the issue of an invoice. So in other words, it wasn't a valid term of the contract to say that the final date for payment was a number of days after the issue of an invoice. The only valid contract term would have been if the final date for payment was a number of days after the due date, regardless of when any invoice was issued. And because the term that was in this contract, therefore, wasn't a valid term for determining when was the final date for payment, the scheme for construction contracts was applied. As you'll know, the scheme steps in to be the fallback provisions if parties don't properly deal with things in their contract. And that provides for the final date for payment being 17 days after the payment due date. And as a result, the payment notice that Rochford had given, which I think was something like 5 months after the payment due date, was well out of time. And as such, Rochford was therefore ordered to pay the full amount that Killian had applied for. So moving on then, just that's it, that's the next slide. Moving on, what lessons do we take from that case? Well, I think the first is the one I've already made, that if it is intended that there will be a set date by which an application for payment is to be made, then clear words making that clear need to be included in the contract. The argument that Rochford tried to argue here wasn't successful because the words were not sufficiently clear. I think this case, though, probably will has attracted the most attention because of what's decided about not being able to link a final date for payment to the receipt of an invoice. And I think that's likely to be of paid particular attention because it's fairly widespread in my experience that within the industry, construction contracts do try to do that, to link the final date to the issue of an invoice. And the reasons for that are understandable, particularly in relation to VAT invoices. Receiving parties don't want to issue a VAT invoice and incur a VAT liability for anything more than they know they're actually going to get paid. and equally, paying parties often have procedures that prevent them from making payments without having received a VAT invoice. However, the message from this case is that a payment provision that has a final date for payment only linked to an invoice and not a set number of days after the payment due date won't be valid, and you may find yourself then being governed by the fallback mechanism in the scheme if you could try to go down that route. And I think what we may see as a result, therefore, and given what I think I suspect out there is probably many contracts that now don't have a valid payment provisions, is the potential for a greater number of these smash and grab type adjudications where people look back at their application and try to argue that because of the invalid payment terms, the proper notices weren't given by the paying party, and try to therefore claim what was applied for in the first place. Probably the most practical advice I can give you is twofold. Firstly, review your contracts. Any contracts that you are now entering into, you need to be sure that the final date for payment is going to be linked to the due date and not to the likes of an invoice. In terms of existing contracts, whether they're your contracts, whether they're contracts that you're administering, if they do purport to link the final date for payment to an invoice, the safety first approach, I think, is to calculate when for the likes of a pay less notice would have to be issued if the scheme applied, and if that's earlier than when you would otherwise be issuing a pay less notice, then take the earlier date and issue your pay less notice early to ensure that even if the scheme does apply, then you're covered in that respect. I think just then on a sort of closing thought on that case, I think it's one that the courts may revisit, because it is, as you say, this practice of linking to invoices is fairly commonplace in the industry, and therefore I think it's one that is likely to trouble the courts again in the future, and so one maybe to keep an eye on as we go forward. Okay, the second case then that I wanted to mention is in relation to something called the correction principle, and this is again looking at the concept of a smash and grab adjudication, and if you are unfortunate enough to be on the wrong end of such an adjudication because in relation to one payment application the appropriate notices weren't served and an adjudication was brought against you by the payee to claim for the amount that they'd applied for, can you correct the position then in future interim payments to try and recover what you'll consider to be an overpayment at that stage? And this was the issue that was addressed in this case of J&B Hopkins against Trant Engineering. Just a decision in May of this year, and Trant had engaged J&B as its M&E subcontractor for a recycling plant in the Isle of Wight. The original subcontract sum was some 1.6, nearly 1.7 million. But as often seems to happen in the cases we see that end up in a dispute, the scope of work had varied considerably. Indeed, I think the suggestion was that the anticipated final subcontract sum was going to be about twice the original subcontract sum. So there was clearly a very significant number of variations that had occurred during the works, and the amount that was due for them was in dispute. Now, the particular issue that arose here was around an interim application that J&B submitted in July 2019, known as interim application 26 for 800,000. That application ended up in an adjudication, and the adjudicator decided that Trant had not given any valid payment or pay less notice, and that therefore J&B was entitled to be paid the full amount that they had applied for, the 812,000. Trant, dissatisfied with that, refused to pay what the adjudicator had decided, and so J&B took the matter to court to try and enforce the adjudicator's decision. Now, the enforcement proceedings here were perhaps slightly different to many enforcement proceedings that are, or many attempts that parties make to resist enforcement. Normally, the basis for seeking to resist enforcement of an adjudicator's decision is because there's some allegation that the adjudicator has acted outside his jurisdiction, and therefore that the decision should not be enforced as a result of that. That was not the case here, and there was no allegation or challenge taken by Trant to what the adjudicator had done in terms of his jurisdiction. However, what Trant did point to was the fact that the adjudication had been in relation to this interim application 26 from August 2019. But by the time the case came before the court in May 2020, the contract had marched on, and the parties were already up to interim application 33. And Trant said, and it doesn't seem to have been challenged before the court, that in relation to all the subsequent applications between 26 and 33, they had served valid payment and pay less notices, and sought to correct the position from their previous failure, and that therefore those subsequent applications and the subsequent notices that Trant had served superseded the one application that the adjudicator had been asked to look at, and that as a result it would be unfair, manifestly unjust, to use the language, for the adjudicator's decision now to be enforced in the light of the subsequent applications and payments. And that essentially is an attempt to rely on what's referred to as the correction principle. And the judge, in the first part of his judgment, said yes to Trant, there is such a thing as the correction principle, and he described it as set out there on the slide, that if an interim application is subject to a failure by a party to issue the required notices, leading to a result that by that failure the sum applied for becomes due, which is what had happened here in relation to interim application 26, then any correction to reflect the true value of the work and the application is permissible on later applications. So that was decided in Trant's favour. But unfortunately for them, there was a sting in the tail, and the sting in the tail was that the judge said that whilst the correction principle does exist, the fact that a failure to issue the correct notices has been corrected in later applications doesn't alter the amount that was due under the original application, and that still has to be paid. the later applications weren't grounds for granting any sort of stay of execution or in refusing to enforce the adjudicator's decision. The dispute between the parties and the amount that was due under interim application 26 was not superseded by the fact that there were further payments and further applications made after it. And the basis for the judge coming to that conclusion was that he pointed to the fact that in construction contracts very often they work on a monthly payment cycle. Adjudication, on the other hand, whilst it's quick, it's very difficult for an adjudication to get from start to finish in only a month. It's usually a little bit longer than that, and even longer still if enforcement proceedings are needed. And the judge said it would therefore be virtually impossible for a party who wasn't paid, despite the absence of notices, to react to that and bring an adjudication and get a decision in its favour before the next payment application was due, and that to have agreed with Trant and allowed them not to pay the application that the adjudicator decided would then have been to seriously undermine the protection that the Construction Act in England, the Construction Contracts Order here in Northern Ireland, provides for payees who are not in receipt of payment notices or pay less notices. And I think the quote there on the last bullet point on that slide from the judge is one worth paying particular attention to. He said that serving the relevant and required notices is not an impossible or Herculean task. Failure to do so has certain consequences, as Trant saw. These are widely known, and this judgment provides another example. In short, the judge, and I think most courts, will have little sympathy for parties who fail to serve the notices that they are required to serve and then complain when they're on the wrong end of a smash and grab adjudication. The view the courts take is that you could avoid that fairly simply by serving the appropriate notices, and if in effect parties only have themselves to blame if they don't do that. This case is another example of a long line of the courts being very clear and strong in giving or looking to enforce adjudicators' decisions when they can. And in our experience, adjudicators' decisions are enforced far more often, in fact virtually always, and it is very rare to see examples of non-enforcement. And so I guess the finishing point I would say in relation to that case is be aware of what notices you're required to serve, and be prepared to get them in on time, and that's the best protection against falling foul in the way that Trant did. And so on that point, I'll hand over to John now, and he'll take us through a couple of other interesting developments.
Thank you, Stuart. Just two interesting cases there described by Stuart, and in particular the case that referred to final dates for payment and the invoices is of great concern to our consultant clients, particularly those that are involved in administering contracts. And he's pointed out that if you are administering any contracts that do peg a final date for payment to provision of an invoice, to watch out for that. It does provide an opportunity for you to provide added value to your clients, to protect them, and just to be aware, it's not just bespoke type contracts that process is written into what we call the standard forms. Some of them, for example, NEC4 contracts, some contracts in that suite. Stuart then talked us through two cases on payment primarily. The other aspect of the construction contracts Northern Ireland order is adjudication, which came up certainly in that second case. But before I go on to talk about three other recent cases, and apologies in advance, it may be a sign of the times, but each of those cases refers to either insolvency or high gearing or the risk of liquidation, but I'll try and be as I can throughout. But as a bit of a brief recap to start, adjudication is a method of alternative dispute resolution designed specifically for the construction industry. And while the cases I'm going to talk about refer to contractors and subcontractors, it also applies to consultants. So the payment processes that Stuart described and the right to adjudication also apply to professional appointments. Adjudication comes from a time not too long ago when there was a report commissioned by a Tory government in the 90s, which identified a problem in the construction industry, which was long-running arbitration or court proceedings, keeping parties out of payment for parties that couldn't afford to finance either court or arbitration proceedings. That meant they had no reliable means to enforce their rights to payment, and was an issue particularly further down the construction chain. The construction contracts Northern Ireland order and its English equivalent, the less snappily titled Housing Grants Construction and Regeneration Act, brought in a right for parties to construction contracts to refer a dispute to adjudication. And what that would be the appointment of an independent adjudicator who would provide a decision within 28 days of the referral of a dispute to him or her. And that decision would be binding, at least on an interim basis, until the dispute was finally resolved by either a court or an arbitrator or by agreement. But that, in theory, was meant to allow for a cash flow remedy for parties to get money moving through the supply chain in a relatively short space of time and in a relatively cost-effective manner. In terms of cost effectiveness, adjudicators do not have the power to decide that one party should pay the other's legal or other expenses in the same way that a judge or arbitrator might. An adjudicator does, however, get to decide who pays his or her fees and expenses. So depending on what side of an adjudication that you end up on, there is a risk of some payment being required. It was, as I say, intended as a cash flow remedy. It's much broader than that now. We see adjudications quite often arising months, if not years, after projects have practically completed. And it's not just in relation to payment. For example, we would see disputes around professional negligence allegations being decided on adjudication. Some debate as to whether adjudication is an appropriate forum for such disputes, but it does happen. The first case that I want to talk about, to give you the lingo that I'm going to be discussing, it's going to be a Northern Ireland case, but what the court was asked to consider was a stay on execution. So this was a case in which a party had obtained a decision in its favour, and there was no reason why it wasn't entitled to judgment from a court on foot of that decision. However, as I said, adjudication was intended as an interim binding process. So if there was a risk that money would change hands and the party that was paying wouldn't be able to recover amounts if it was later found to be entitled to do so, that is one circumstance in which a court can step in and grant what's called a stay of execution. Essentially, it puts the foot on the ball in terms of requiring payments. The first case in Northern Ireland showed just how flexible courts can be in that regard. It was a case from 2012 of Rogers Contracts and Merrick's. Rogers had successfully obtained a decision from an adjudicator against Merrick's for some £140,000 in relation to work that it had done. There was allegations going the other way in terms of defective concrete having been provided. There was then remedial works and a payment up the line to the ultimate client, and Rogers sought to, through an arbitration, recover the amount of that payment. So the court was faced with a company that had a decision for payment. It was in a CBA, likely only to be pence in the pound of any recovery, and another company that was potentially going to be entitled to repayment on foot of an arbitration decision, which was due in a matter of weeks. And what the court did there was to try and balance the right of the party with the adjudication decision to payment and the risk that it would be unable to repay those monies if the arbitration decision went against it. So the court actually required a stay in that case, so the money wouldn't end up changing hands, but to make sure that it was safe for both parties, as there was a risk of financial difficulties both ways, the money had to be paid into court, essentially ring fencing it, so that it was there and the arbitrator would get the final say on the merits of the dispute between the parties in terms of the defects, and it could be paid out after that event. More recently then, the case of QMAC Construction and the Northern Ireland Housing Executive, Stuart described what was called smash and grab decisions. The Northern Ireland Housing Executive found itself on the wrong end of not just one smash and grab decision, but two. There was two separate contracts, both relating to improvements to the NIHE's housing stock, both under NEC engineering and construction contracts. And in total, the decisions were around £210,000. It was found that no payment notices or pay less notices had been served. So QMAC was successful in obtaining two decisions, not just for the amounts that it had claimed, but also significant amounts in relation to interest. To put that up there in a bracket too, nearly as much as the amounts due. The NHE wasn't happy, didn't agree with those amounts, and it started what was termed true value adjudication, so trying to get into the nuts and bolts of the value of the work that QMAC had carried out, and those adjudications were ongoing and decisions awaited by the time this case made it to court. I mentioned that interest in particular because it was clear to all the parties, and I think the judge too, from the judgment, that the adjudicator had made an error in his calculations on interest. It was significantly more than perhaps QMAC ought to have been entitled to, but the court in this decision confirmed what has been confirmed many times before, in that just because an adjudicator gets his decision wrong, he gets either a fact or point of law wrong, that isn't a reason for not enforcing. So QMAC was able to get judgment in its favour, but the real issue and battleground in this case was whether or not there ought to be a stay of execution. On the Rogers Contracts and Merrick's case, there was a fairly obvious CBA in place, with also the risk of liquidation following on foot of that. That was not the case. QMAC and the housing executive, both parties relied on reports from chartered accountants, and neither said that QMAC was insolvent. Indeed, it had reported profits in each of its last 3 years, but it had increased cash flow in its last accounts. There was a drop in turnover and an increased overdraft and borrowing, and it was against that background that the housing executive said that there was at least a risk that QMAC would be unable to repay amounts if it was found that the smash and grab applications were more than it was actually entitled to. So how did the court deal with that? It did so in a relatively broad brush way in its own terms. It gave judgment to QMAC in respect of the full amounts, but it did award a stay for a period of 14 days on the full amounts. Trying to read between the lines, I think those 14 days were likely to be enough for the true value adjudication decisions to come through, which would then allow potentially a further application to the court if the housing executive was successful in them. But the judge went a step further in respect of £120,000 of the full amounts. A further stay was ordered, and that was going to be in place unless and until QMAC made a further application to court. And I think what that was intended to do was certainly to protect at least part of the money and the risk that QMAC would be unable to repay if ordered to do so. But it also in some ways went a long way to righting the wrong of interest in the adjudicator's decision. So £120,000 either by luck or by judgment was roughly equivalent to the larger of the two interest amounts. So again, a flexible approach by the court on that case. I suppose the other interesting thing about it was that decision was given in May 2020. I had rather hoped that by the time we'd be speaking about it in October 2020, we'd be reminiscing about COVID-19 and lockdown implications, but then as now there was an impact on the ability to have in-person hearings in court, either because of social distancing requirements or limits on court resources. And what the court did here was to try something flexible with the agreement of the parties, and it made its decision here only on the papers. So the court considered written arguments and written evidence, but there was no barristers in court making submissions on their feet, as you'd ordinarily expect, and nobody other than the judge made it down to the High Court on Chichester Street. In the judgment, it is remarked that the judge considered that this process worked successfully, and it was done with the buy-in of the parties. And I think then as now, in order to progress, particularly adjudication enforcement hearings, which in order to try and provide a quick and speedy resolution for business parties, the court will attempt to hear within 4 weeks, in a similar way to adjudicators will attempt to come to a decision within 4 weeks of a referral. What we're going to be seeing is the court asking parties to be flexible in order to allow that to continue to happen. But the message from the courts, particularly in relation to adjudication enforcement, is that they are open for business and they will be flexible and practical in relation to ensuring that adjudication decisions are dealt with speedily, even with all that's going on in the world. Now, the next case that I wanted to talk about was one that certainly got a lot of lawyers and insolvency practitioners very excited earlier in the year. It was a case that came from the Supreme Court in London, so the highest appeal court in the United Kingdom. It's rare that we do get a construction contract decision from the Supreme Court, so it did attract a lot of attention at the time. That was a case that evolved out of electrical installation works in London. Lonsdale and Bresco were both electrical contractors, and Lonsdale engaged Bresco under a subcontract. It was not a happy engagement. Shortly afterwards, Bresco stopped attending site and alleged later on that it did so because of a repudiatory breach on Lonsdale's part, but then again it went into liquidation. There were various claims between the parties. Lonsdale had a claim for, amongst other things, the cost of having Bresco's works carried out by another party. Bresco claimed for work that it said it had carried out and was not paid for. This case went to the High Court in London, first off, because Bresco had started an adjudication seeking payment for the work that it had done. Lonsdale went to court and got an order, an injunction order, stopping that adjudication from proceeding. And there were two limbs to that. One came from the insolvency rules, which in relation to cross claims in insolvency applies a set off between them, so that you end up with a net balance. That does actually have important consequences for parties, because as a creditor in an insolvency, you may only be entitled to pence in the pound, but in relation to set off of cross claims, you can set off your cross claim in full, so in effect you get maximum value for it. That argument turned into whether or not an adjudicator would have jurisdiction to decide any dispute, because the impact of that automatic set off in insolvency, it was argued, resulted in there being no longer a dispute under a construction contract, but a dispute over a net balance under the insolvency rules. There was also a debate as to whether or not all of this was an exercise in futility, as we've seen in relation to the QMAC and Rogers Contracts case. It's going to be very rare for a company in liquidation to be able to enforce fully a money judgment. The first court, the High Court in London, accepted both arguments. By the time it made it to the Court of Appeal and another set of judges looked at it, the insolvency set off and jurisdiction argument was dismissed, but the injunction continued because the judges accepted that it was an exercise in futility. The case then made it to another set of judges in the Supreme Court, and what that decision said was that adjudicators did have jurisdiction to decide disputes involving companies in liquidation. As it says on the screen there, those disputes do not simply melt away so as to render them incapable of adjudication. And on the futility point, the Supreme Court disagreed with the Court of Appeal. It said that Bresco had both a statutory and contractual right to refer a dispute to adjudication, and it would be inappropriate for judges or courts to interfere with that right. However, that would, of course, result in questions being posed on enforcement applications, and that is what happened then in the case of John Doyle Construction and Earth. Again, an unhappy engagement, but a long-standing one. This case related back to London 2012 and works done in preparation for the Olympics. So a long time in coming to the courts, certainly. There was landscaping works carried out. There was a final account claim that John Doyle Construction had, but it went into liquidation in 2013. By 2018, it started an adjudication, which claimed some £4 million on foot of that final account. The adjudicator decided it was due to be paid 1.2 million. The court in that case then set out the principles that have to be considered when an application comes before the court to enforce an adjudication decision in favour of a company that's in liquidation. And they're all on the screen there. I think there was some speculation that following on from the Supreme Court decision in Bresco that there might be a run of cases brought by liquidators or administrators through adjudication. I think this is likely to put the brakes on that to a large extent, if ever it was a genuine concern. Taking them in turn, the first is the dispute in respect of which the adjudicator has issued a decision, one in respect of the whole of the parties' financial dealings. On my reading, that seems to limit the types of adjudication that we're likely to see to final account disputes. The judge specifically ruled out the smash and grab disputes and tightly defined tactical disputes as being ones that would be enforceable. So I think, although it wasn't specifically mentioned, the likes of a professional negligence dispute probably wouldn't be appropriate for enforcement by or on foot of a decision in favour of a company in liquidation. The next 2 points on the slide, the judge actually admitted maybe 2 different ways of saying the same thing, but essentially, if there were other matters between the parties, for example, amounts due on other contracts or other defences that may be available, then those were issues that ought to be taken into account by a judge on enforcement. And again, then the 4th and 5th really get to the nuts and bolts of whether there is a real risk that the paying party will be deprived of an opportunity to recover. And I think the judge again said they may be the same way of saying the same things. In this case, the decision wasn't enforced, and that was because John Doyle really fell down on these 2 points. It was a final account dispute, so it got over that hurdle, but there were no undertakings from liquidators to ring fence and preserve monies, and the security offered by John Doyle was said to be inadequate. What was proffered as a letter of credit was in fact a draft letter of intent to apply for a letter of credit, and there was also an ATE, or after the event insurance policy, that was intended to cover some cost risk, but again, the judge wasn't impressed by that. It's under its terms, they were inconsistent with the letter of credit, and also there were some exclusions in there which were concerning to the judge. So I think the key takeaway is that there probably won't be an avalanche of claims in adjudication brought by adjudicators, or brought by companies in liquidation, sorry, which is good news. But I think with all that's going on in the world, I would give some thought to what you can do to protect yourselves as consultants from being in a position where you're in a contract with a party that's in liquidation or some other insolvency process. Obviously, there's competitive market out there for work, but in terms of any new clients, certainly recommend that financial checks are carried out beforehand, that clear payment provisions are agreed, and that if you're going to be carrying out work, to make sure that you don't let a lot of payments build up, to make sure that you're enforcing your rights on each milestone, rather than let outstanding monies build up, and also query whether or not it's going to be possible to maybe ask for money on account, particularly with new clients where you've got no history of working with them. I think that brings me to the end of those 3 cases, other than to say, in relation to adjudication enforcement, the judge criticised the length of time between the works being carried out and the adjudication and the subsequent enforcement, some 8 years or more. Both the courts here and in England have an expedited process for adjudication enforcement, but what the judge said in respect of this case is that expedited process may not be appropriate for antiquated projects and disputes arising out of them. I think that may be a point that our courts pick up on in Northern Ireland as well. So one to watch out for. As I said before, our commercial court seeks to expedite adjudication enforcements and have them heard within 4 weeks. But if you want to avail of that process as a party trying to recover money, I think the key is not to dwell on things and to action any disputes as and when they arise.
Thanks for that, John. We were going to try and answer a few questions, but I'm conscious that we're sort of up against the end of our allotted time slot. So maybe the thing to do would be we'll take a look at the questions that have come in and maybe give some thoughts that the ACE can put with this presentation when it goes up on your website, Paul, if that's all right.
Yes, I think that's fine, Stuart. We are, I think, out of time, unfortunately. Can I thank everyone for listening? I hope you found it very interesting. Let's hope we're not moving into a period of time when we're going to face a lot of companies going into liquidation. And John has highlighted a few of the pitfalls for people that are engaging with such companies. Can I specifically thank both Stuart and John for taking the time to present to us today? Very interesting insight into some recent cases, and I hope we've all taken something from it. And thanks everyone for taking the time to join us as well. Just a reminder, as Stuart said, this webinar has been recorded and ultimately will be uploaded on the institution's website along with a copy of the slides. On the screen at the moment are a number of our upcoming webinars. Feel free to register and join those as well. So many thanks indeed, Stuart and John, and all the best, everyone. Thank you.
Thank you, Paul.
Thank you.